Good afternoon, learned colleagues. My name is Achilles Romot, and I do work with East Africa Law Society. I will be your moderator today. Thank you for taking your valuable time to join us today as we are finalizing the 3 set of webinar series on privacy in an enterprise context. For those who would not attend our previous 2 webinars on this subject, you can access the recordings through the East Africa Law Society YouTube channel. All these recordings that we have done for these 2 previous webinars, they can be accessed through our YouTube channel, which is called East Africa Law Society YouTube channel. Briefly, part 1 of the webinar dealt with the introduction to privacy program management. This session discussed privacy program management, and our organizations are looking to ensure that they are compliant with the regulation, such as General Data Protection Regulation and other national laws and regulation within their business jurisdiction, in order to protect their brand name, reputation, consumer trust in the work of increasing global data breaches. So that was basically what we covered under part 1 of the webinar on this agenda. Part 2 dealt with privacy governance. Under this part, the session discussed the governance framework for establishing a successful and strong privacy program within an enterprise. That is, components that guide a privacy function towards compliance with privacy laws and regulations and enable it to support the organization's broader business objectives and goals. So that was part 2 of the webinar that we did. It was on privacy governance, and that was the content that we covered. And part 3, which is today's session, we shall be dealing with data assessments. It is worth noting that a successful privacy program cannot be built and maintained without a comprehensive view of data organization store and processes. Thus, this session will discuss how data assessments can help to inventory and track personal information, as well as determine the impact organizational system and processes that will have on privacy. In all these 3 sessions, the 2 that I've earlier spoken about and today's session, we have been taken through by our cybersecurity and forensic expert, one called Mr. Lawrence Dinga. So he's an expert, he's our expert who have been taking us through all the sessions. So for those who are joining for the first time today, I'll just give a brief biography of Mr. Lawrence Dinga. Well, Mr. Lawrence Dinga is a seasoned international cybersecurity consultant with wealth of experience and expertise in cybersecurity, privacy, and digital forensics capacity building. He trains legal professionals, including lawyers, prosecutors, magistrates, and judges in areas of cybersecurity, cybercrime, electronic evidence, digital forensics, among others. Lawrence is also an approved consultant for the Cybercrime Program Office of the Council of Europe on law enforcement and judicial training in cybercrime and electronic evidence. Lawrence is also a consultant for the European Union Agency for law enforcement training on cybercrime, attacks against information systems, and law enforcement technologies. He is also a digital forensic expert in court and has testified in many cases of cybersecurity and digital forensics. So for those who have court actions and would like his service, he will be readily available, and he'll give, at the end of the session, he'll give us his contacts. Professional-wise, Lawrence holds a master's in forensic computing and security from the University of Derby, England. He holds also an LLM in ICT law from the Open University of Tanzania. Holds a diploma in law from Kenya School of Law, and he is also a system security professional. Has consultants and cyber capacity building experience on the EMEA region, and is the founder and the CEO of Managecom System Limited, a leading cyber security forensics consulting service provider in Africa. Managecom System Limited, his company, strives to deliver state-of-art cybersecurity and digital forensics products solutions and services to individuals, corporate entities, law enforcement agencies across Africa. So that is the brief biography of Mr. Lawrence Dinga. And I would like now to put some few clarifications. If you have any questions, kindly post the same through a Q&A section that it can be easily seen on your screen. Later on, be answered by our expert, and the other session where I shall be having a Q&A section, you'll be able to ask questions even by raising hands, and it shall afford you the opportunity to ask your question. Also, kindly note that at the end of this session, certificates will be awarded to those members who have successfully attended all the 3 webinars. We have names of those people who have been attending, and we shall award certificates to those 3 who have committed their time to attend all these 3 sessions. Without further ado, allow me now to welcome our expert, Mr. Lawrence Dinga, to take us through what he has prepared for us today. Thank you, and Mr. Dinga, you have the floor. Karibu sana.
Thank you very much, moderator. Good afternoon, ladies and gentlemen, and welcome again today on this webinar. Now, what has happened is the moderator has given you the outline of what we've done and what we are going to do today. And incidentally, it happens that whatever we've done is on the flyer from webinar 1 and webinar 2. It is all covered, including what is on the flyer on webinar 3 today. So basically what we are going to cover today, we are still on the privacy governance, but we are going to cover more because we did data assessment last week. So we are going to cover more on what are some of the rights of data subject. So that is what we are going to look at today. And somehow you can also implement some automated tools to help you in privacy within your organization. So without further ado, let me just share my screen. I want us to go to do a recap of what we did last time. Then we can continue with what we are going to do today. I hope everyone can see my screen.
Yes, we can see it clearly.
Okay, thank you so much. Let me just, yeah, okay. So last week or our last webinar, we concentrated on, we focused ourselves on privacy and mostly on the privacy policy. So we looked at the privacy policy is. We say that the privacy policy governs the privacy goals and strategic direction of any privacy office or within the organization. And the privacy policy is a high-level governance that aligns the privacy vision or mission statement with the organization. Remember when we were going through how to build a stable privacy management program, we talked about mission and vision of that privacy program. So it is important that you have a piece regarding what you are going to do. So privacy policy also said it should be appropriate to the purpose of the organization. Privacy policy should be able to provide a framework setting objectives. It should also include commitment to satisfy applicable privacy safeguards and requirements, and privacy policy should be able to be communicated within the organization, and everybody should be able to know what that policy is all about. So if you want to go through this, I think the moderator has said that they have posted this on YouTube, and you can follow. Then we also looked at how do you implement policies within the organization. And we looked at, we say that policy-related, privacy-related policy will not be if it is the individual do not care or follow them. So you have to put out the policy in place, and people must follow those policy for them to make sense within the organization. So organizations should seek ways to enable employees to integrate the policy in their daily lives. So which daily tasks, which means that whatever you are going to be doing on your daily tasks, privacy should be part and parcel of those daily tasks. And this can only be achieved by aligning those policies with existing business procedures, training employees to observe those policies, and raising the awareness about the policies that are existing within the organization. And we also saw that in a multinational organization, there may be additional challenges to ensure that policies are consistent and uniform across all locations, while at the same time, those policies are satisfying the local laws, regulations, and industry governance guidance, which means that you might you will be able to observe the local laws and regulations, and at the same time, depending on the industry that you are operating in, you'll be able to, the policy might be able to observe those. So raising awareness and proper training of employees and data users is key to knowledge transfer and retention. Then we looked at the data assessment, and what we said is that a successful privacy program cannot be built and maintained without a comprehensive view of the data within the organization. What kind of data does the organization collect and process? So without having this inventory of your data, then there's no way you are going to build a successful privacy program. Your data assessment is something which is very, very crucial when you are putting up a privacy program. So data assessment helps to inventory and track personal information, as well as determine the impact the organization systems and processes will have on the privacy. And data assessments are also tools that can help you to identify privacy risks to individuals in advance and deal with them effectively at the beginning of the project before things go bad. Then we looked at what we call the privacy impact assessment. We say that a privacy impact assessment is an analysis of the privacy risks associated with processing personal information in relation to a project, a product, or a service. Within your organization, maybe you intend to start a project, or you are developing a product, or you are developing and offering a service. So before you do that, you need to do what we call the privacy impact assessment to help you identify those privacy risks associated with that project that you want to undertake. So we also noted that privacy impact assessment should suggest or provide remedial action or mitigation necessary to avoid or reduce those risks, because you do impact assessment, you identify those risks, and then you come up with mitigation measures on those risks so that you can reduce them to minimum level. Then we also looked at requirements regarding privacy impact assessment emanate from industry codes, organizational policies, laws, regulations, and supervisory authorities. And PIA can also help facilitate privacy by design, which is the concept of building privacy directly into technology, systems, and practices at the design phase. Then after that, we also looked another crucial aspect we looked was data protection impact assessment. And we say that when an organization collects data, collects, stores, and uses personal data, individuals whose data are being collected are exposed to risks. And these risks include things like impersonation or things like identity theft. So a data protection impact assessment is designed to identify the risk arising out of processing personal data to minimize those risks. So in some places, you'll find that the data protection impact assessment is used interchangeably with the privacy impact assessment. However, the difference is that the data protection impact assessment is something that is enshrined in most of this data protection law, like the GDPR. If you are adhering to the GDPR, then you need also to look at the data protection impact assessment. And we looked at when is this data protection impact assessment required. So in a case where processing is likely to result in a high risk to the rights and freedom of natural persons, then at that point, if you are going to undertake data collection or data processing, but that project is likely to result in a high risk to to the rights and freedom of natural person, then you need to do what we call the data protection impact assessment. We also saw that data protection impact assessment is the process by which companies can systematically assess and identify the privacy and data protection impact of any product or they offer or services they provide. So those services, provided they meet that criteria, that they are likely to result in high risk to the rights and freedom of natural persons, then they need to you need to undertake data protection impact assessment. Then we looked at something we call the privacy by design, and we say that this concept was developed in the 90s by Anne Kavokian, who is the former Information and Privacy Commissioner for the government province of Ontario in Canada. And the concept dictates that designing for privacy must begin during the development phase of a system and continue into its life cycle, which means that when you are developing a system, when you are developing a product, when you are developing a service, then you should be able to ingrain the privacy from the onset, which means that privacy must start from the development phase and continue throughout into the life cycle of data, which means that privacy should not come as an afterthought. It is something that should be embedded within that particular product from the development phase. So the core goal of privacy by design is to embed privacy within a technological system as an integral part of the design, and do so ex ante and throughout the technological life cycle, rather than to fix it ex post when it is often too late or expensive. And we found that this privacy defined by design concept has gained recognition with the US Federal Trade Commission and also within the European Commission. And then we also looked at some of the 7 principles of privacy by design. And we looked at that the privacy design is proactive, not reactive, preventive, not remedial. We also look at privacy should be as the default. We also look at another principle which says that privacy must be embedded in the design. Also, we looked at that another principle which says that it should be full functionality, positive sum and not zero sum. The other principle was end-to-end security, full cycle protection. And the other one was visibility and transparency. And then the last one was respect for privacy, respect for user privacy when you are designing privacy by design. So that was what we saw last week. So today, as I said, most of the things, everything that is covered on the flyer from webinar 1 to webinar 3 has been covered in those in those 2 webinars. So today we are just going to look at another part. Let me just share my screen. Yeah. Yeah, so today what we are going to look at, we are still on privacy in an enterprise context webinar, and we are going to look at part 3 today. Sorry, here it is put it part 2, it should be part 3. And we are still just talking about privacy governance, and what we are going to look at today is on data subject rights. Who is a data subject, and what are some of the rights that you have as a data subject? Now, what is a data subject, or who is a data subject? A data subject or data subjects are identified or identifiable individuals whose personal information is being processed by an organization. This can be a patient at a medical facility. You go to the hospital and your information is taken, your personal information is taken. And it should be an employee of a company. When you are employed with a company, then there are certain information which are personal, which are collected by the organization. You can be a customer at a retail store, whereby you are going to buy things. Maybe you'll use your credit card, which has got your personal information, or it could be a visit to our website, whereby you give your information to that particular website. So data subject rights vary across jurisdiction and include the right to know how their personal information will be used, and the right to opt out out of certain processing activities, which means that you have the leeway, you have within this jurisdiction where we have this data protection acts, the authority has been given to the data subject, and they should be able to know what kind of information is being used, is collected from them, how that information is being used, and how, if they can be able to opt out of the processing activity. That is a right of the data subjects. So data subject requests may come directly from the data subject, or organization may need to assist business customers in fulfilling the data subject requests. Now, another thing which is also important is that preparing to respond and effectively responding to data subject requests is a critical component of any privacy program. Whatever privacy program that you are going to put in place, you must take into consideration how you are going to give that data subject their information if they request it. So that how you respond to that will determine how efficiently your data, your privacy program is stable. Now, some laws requires a response without undue delay or within a certain set period, which means that when the data subject requests this data, you should be able to give it within a certain period of time. Like in GDPR, I think it is 1 month. If you request your data should be given within 1 month. So various data protection regimes have their set period when this data is supposed to be given to the data subject. Now, organizations run the risk that a poorly handled response to a data subject request would result in a subject making a complaint to the regulator or supervisory authority, or going public with a complaint against that organization. For example, if you hold my data and I'm requesting you to give me that data, and you cannot give it within the stipulated time, then I have the right to launch a complaint with the regulator or a supervisory authority, or I can decide to go public and accuse your company of this negligence. So timely and effective response to data subject requests is paramount importance to excellence customer service and brand protection. So which means that internally within the organization, you must have to put these processes and procedures of making sure that you can be able to handle these requests that are coming from data subject efficiently, because this is actually paramount importance to excellence in the customer service as well as brand protection. Now, when you talk about personal data, what do you mean by personal data? So personal data means any information relating to an identified or identifiable natural person or the data subject. I think this is something that we defined by the first time that we were introducing this webinar, when we talked about protection of personally identifiable information. So personal data is just that personal, what is related to identified or identifiable natural persons. So an identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier, such as a name, an identification number, location data, online identifier, or to one or more specific factors such as the physical, physiological, genetic, mental, economic, cultural, social identity of that natural person. So this is a definition from the GDPR. So what we're saying that some of these identifiers include things like identification number. If you have your ID, that is enough to identify you. Something like location data, where you are located, that can also be identified. Online identifier like IP address. IP address is part and parcel of personal data. So those things that can be able to identify you, those are that are considered personal data. However, there are also what we call sensitive personal data. Now, sensitive personal data are data revealing things like racial or ethnic origin, political opinion, religious and philosophical beliefs, or trade union membership, and the processing of genetic biometric data for the purpose of uniquely identifying a natural person, data concerning health, or data concerning a natural person's sex or life, sexual orientation. So if you encounter such kind of data that are listed here, that means that those are sensitive data, sensitive personal data, and each and every data protection regime have got a way they stipulate a way of handling or processing sensitive data. So sensitive data will be processed differently from processing other normal personal data. So what you have to know that sensitive data is still personal data. Sensitive personal data is still personal data, but they are put in a different category, and they are processed differently in many of these data protection regimes. Then we talk about some controller and processor. We looked at this in our previous webinars, and what we said is that a data controller is the natural or legal person, public authority, agency, or any other body, which alone or jointly with others determines the purpose and means of processing the personal data. That's data controller. So for example, right now you have your bank. Bank has got your data, which include your name, your ID, the amount of money you have there. That is data controller. So they determine how they process that data. They are actually the decision maker with regards to personal data, and has got the responsibility for compliance with the regulation of that part of protection of that particular personal data. While a data processor is a natural or legal person, public authority, agency, or other body which processes personal data on behalf of the controller, which means that they can process that data, but they don't determine the purpose of that processing that data. They don't determine that, so they are just processing on behalf of the controller. So we have nowadays, we have people like Safaricom, we have agents everywhere. Those are what you can call data processors. The existence of data processor depends upon the decision by the contractor to delegate all or part of the processing activity to an external organization or an individual. Then what do we mean by processing? If we talk about the processing, collecting and processing data. Now, processing according to the GDPR is any operation or set of operations which is performed on personal data or sets of personal data, whether or not by automated means, such as collection, recording, organization, structuring, storage, adaptation, or alteration, retrieval, consultation, use, disclosure by transmission, dissemination, or otherwise making available alignment or combination, restriction, or erasure or distraction. So that is what the GDPR define as the processing. So the processing must be only or partly carried out by an automated means. And this is why when we come to towards the end of this webinar, we are going to see some of the tools, that automated tools that you can use to in your data privacy management program. So where the processing is not automated, is not by automated means, it must concern personal data that forms part of a filing system or is intended to form part of a filing system. So what do we mean by filing system? It is a system that is refers to a structured set of personal data that is accessible to specific criteria, which means that when we are talking about processing, we are not only talking about automated processing. You can also be talking about processing which involves a physical filing system, and when you are handling that, then that's still part of the processing, but in a manual way. We also looked at something on privacy notices and policies when we were I think on the second webinar. And what we said is that it is always very crucial to provide data subject with information about privacy practices at the time of personal information collection. When you are collecting this data from this data subject, you need to provide them with enough information to help them to make decisions. And this is always provided through the privacy notices and policy. Now, we say that a privacy notice is an external statement directed to the current or potential customers or users, and is a tool that is used to describe the organization privacy practices. So when you visit an organization's website, then they should have what we call the privacy notice, which shows you how the organization handles data, what are the organization's privacy practices. So what you need to know here is that privacy notice is an external document, while privacy policies are more of internal documents. So privacy policies are internal documents directed to employees, contractors, that describe how the organization will handle personal information. When you are employed within an organization, then you'll have a privacy policy to show you how they will be handling your personal information. So both these privacy notices and policies, what is common with them is that they describe how personal information will be collected, used, and stored. They should also be very clear and easy to understand. They should be accessible. They should be comprehensive. They should be action-oriented and measurable. Now, let's narrow down to more of the privacy policy notice, because privacy notice is how you communicate your privacy agenda to the outside world. And it is important, it's something which is important because you need to make sure that the world knows how you are handling your privacy aspects. So a privacy notice can help an organization comply with the applicable laws, but it does not provide a blanket protection from privacy-related litigation, which means that even if you put your privacy notice on your website, just know that it will not, it will help you comply with the laws, but what it does not do is that it will not give you a blanket protection for privacy-related litigation, which means that if somebody you go against what you're supposed to do, then somebody can raise a litigation against you. It does not mean that if you have a privacy notice, then you are immune to it. So that is what that statement is. So a privacy policy notice should be considered a promise the organization makes to the data subject. So which means that when somebody visits your website or whatever product that you are offering or service that you are offering, then that privacy notice is a promise to that particular customer on how you are dealing with the privacy. So if the organization breaks those promises, it may face regulatory action or litigation. In a case where there was a breach of privacy on Snapchat, this is what the Edith Ramirez, who was the chairperson of the FTC, that is, this is what she said. If a company markets privacy and security as key selling points in pitching its service to consumers, it is critical that it keeps those promises. Any company that makes misrepresentations to consumers about its privacy and security practices risk FTC action, which means that whatever you put there in the privacy notice, that should be something what you actually do. You don't put something that you don't actually do in your privacy notice. Now, what are some of the common elements of privacy notice? An organization needs privacy notice will typically provide the following information: who your organization is and your organization's contact information, what information is collected directly or indirectly, how your organization will use the information, or with whom the organization will share that particular information, how the behavior of website users is monitored, if you're using cookies or something like that, and how data subject may exercise their rights. So this must come out very well within your privacy notice. Now, design privacy notices, because what we say is that privacy notices are living documents. They are maintained in a life cycle that includes designing and developing, testing, releasing, and reviewing, and updating where necessary. So when designing a privacy notice, you need to take into consideration which audience or who are the users and how the users will view it. Are they going to view it on a computer screen? Are they going to view it on a mobile device? Are they going to use a home appliance? Because you find that many of the users, they never read those privacy policies. So you have to make sure that you put your privacy policy in a way that will entice these people to read it. So it is also important not only to consider the primary users, for example, the car owner or the homeowner, but also other users whose information could be collected. So you need to take it into consideration. So the goal of a privacy notice is to help the recipient make informed decision. So how do you do this? There are ways of designing your privacy notice. One of the ways is called a layered approach, which provides a high-level summary of various sections of the privacy notice and allows the user to read more about the section by clicking a link or that section or scrolling below. So that is a strategy, what we call a layered approach strategy, where you provide high-level summary information, but when the user needs to go deep, then they click a link or to that section and or scroll below to see more information about that particular privacy notice. So Working Party 29 guidance on transparency says that design and layout of the first layer of privacy statement or notice should be such that the data subject has a clear overview of the information available to them on processing their personal and how they can find that detailed information within the layers of privacy statement or notice, which means that the information is put in layers. Okay, so if you need more information about a certain section, then you click that section, then you will be able to find more information. There's also another technique called just-in-time notice, whereby you provide information immediately before data collection. For example, sometimes you have seen some mobile apps that can tell you, okay, we need to activate your camera, or we need to activate your location, something like that. So that is what we call just-in-time notice. So more information is typically available by clicking a link, hovering over the notice. And this technique is used when providing information at various points throughout the data collection process. So the other technique is what we call the privacy dashboard, which offers summary of privacy-related information and metrics, and is easy to access and navigate, and provides more personalized privacy notices and choices to data subjects. So privacy notice, as you say, is something that is very important because it helps the data subject make informed decision when you are collecting their data. So it is important that these people, you give them enough information to help them make a decision. Otherwise, you might be collecting their data without their consent, sort of, because they don't understand exactly what you are collecting and how you are going to use that data. So this is where privacy notice comes in handy. So some of the rights that accrue to data subjects is one of the right is called the right to information. Now, data subjects have the right to be provided with certain pieces of information that describe their relationship with the controller. Something like the controller identity and contact details. Who is the controller collecting the data? Who the identity of that controller? The contact details of that controller. That shows the relationship between the data subject and the controller. The reasons or the purpose for processing personal data. That information should be given freely to the data subject. The legal basis for processing. That they should, if they need that information, they should get. Recipients of that data and other relevant information necessary to ensure fair and transparent processing of their data. Who is the person you are sharing this data with? You need they need to give them that information if they are looking for it. And the source of data, if collected or obtained from a third party, in order to effectively enable the data subject to pursue their rights. So that is what we call the right to information. And that is a right that the data subject has. And when they need that information, they can be given. There's also the right of access. Now, in the right of access, what it says is that the data subject has the right to obtain from the controller confirmation as to whether or not personal data that concern him or her is being processed, including the purposes of the processing, the categories of data, personal data concerned, the recipients or categories of recipients to whom the personal data have been or will be disclosed, in particular, recipients in third countries or international organization, or where possible, the envisaged period for which the personal data will be stored, or not possible, the criteria used to determine that period, how long you are going to store that personal data, and what is the criteria that determines that particular length or period of time. So that is what we call the right of access. Now, the existence of the right is continuing we say that the data subject has the right to obtain from the controller confirmation as to whether or not personal data that concern him or her is being processed. So these are some of the inclusions we've looked at up to number 4. There is continuing the existence of right to request from the controller rectification or eraser or personal data or restriction or processing or personal data concerning the data subject or object to such processing, which means that if there's some data which is wrong about you and you need them to be deleted, then you have the right to do so. So you have the right to tell the controller to rectify or erase that personal data, or you can object to the processing of such data. Also, the other one is the right to lodge complaint with a supervisory authority. If you are not happy with something which the data controller is doing with your data, then you can report them to the supervisory authority. That is within your right of access. Or where the personal data are not collected from the data subject, any available information as to their source. If the data is not collected from you, but they have it, how did they get it? What any information about available on the source of that data. Also, the existence of automated decision making, including profiling, information about logic involved in the profiling, the significance and envisaged consequences of such profiling, such processing for the data subject. Then there is also the right to rectification. On the right to rectification, we say that the data subjects have the right to rectification of inaccurate personal data, which means that if data has been collected, your personal data has been collected and it does not really represent what you are, then you can be able you have the right to rectification of that inaccurate personal data. So controllers must enable the inaccurate or incomplete data to be erased, amended, or rectified. So this right can generate a considerable amount of effort operationally. Yes, we understand that, but the data subject has got the right to rectification, rectify or erase the personal data which are inaccurate about them. So rectifying wrong entries in database is usually not a singular isolated issue for organization, because data is stored in database. So this is not something that is new to many organizations. So data is often interlinked and processed in that way. So any changes to any piece of data might have a wider consequences. So this is why we use technology and in collecting and storing this data, so that these things can be automated, so that if you can delete one piece of data, then if it affects the other pieces of data in a way that that can bring some consequence, you need to see how best to delete or to erase that particular data. So the right to eraser that we just looked at that also, and we say that the data subject obtain the right to have their personal data erased if the data is no longer needed for its original purposes and no new lawful purpose exists. The data, your personal data has been collected, they have been processed, and now there's no more use for it. So you can ask the data controller to delete, to erase that data. If the lawful basis for the processing is the data subject consent, the data subject withdraws that consent and no other lawful grounds exist, then that data can be erased, which means that if you allow your data to be processed, and then in the process you withdraw that consent, that explicit consent, then and the controller does not have any other lawful ground which they can use to process that data, then that data should be erased. Now the data subject exercises the right to object, and the controller has no overriding ground for continuing processing. If you object to the processing, then the controller will have no any other ground to continue processing your personal data. or the data has been processed unlawfully, or erasure is necessary for compliance with national law of the relevant jurisdiction. So where the data has been processed unlawfully, I think you can, the e-citizen, it was an uproar when many of us found that they've been registered to political parties that they don't even give their information. So such kind of unlawful processing, they have to be make sure that those data are deleted. So what are some of the exemptions of this eraser? So organizations can decline data subjects request to the extent that processing is necessary if for exercising the right of freedom or of expression and information, then the organization will refuse your request for eraser, or for the compliance with a legal obligation which requires processing by national law to which the controller is subject, or for the performance of a task carried out in the public interest, like the public health, archiving, and scientific, historical research and statistical purposes. In that case, you cannot be able to tell the organization to release your data because it is for public interest. Also, for the establishment of exercise or defense against legal claims. So those are some of the exemptions to the right of eraser, where you cannot go and tell the organization or the data controller to erase that data from their database, only if it meets those three conditions. So there's also the right to restriction of processing, where data subjects have the right to restrict the processing of their personal data if the accuracy of that data is contested, and only as far as or as long to verify that accuracy, which means that if you think that the accuracy of that data is not correct, then you can restrict its processing. So the processing is unlawful. The data subject requests restriction as opposed to exercising the right to erase, which means that you are processing that data unlawfully. Then this right jumps in. Or the controller no longer needs the data and their original purposes for their original purposes, but the data is still required by the controller to establish, exercise, or defend legal rights. Here is a case that your data has been collected by the controller, and the controller has used the data for what it was meant to be, but the controller still needs to control to keep that data, or maybe to establish and exercise some defend some legal rights. Then they'll still have to keep that data. Or verification of overriding grounds is pending in the context of eraser or eraser request. Then there is, I think this is the last one, the right to portability. Data subjects have the right to receive their own personal data, which they have provided to the controller in a structured, common, and machine readable format. They also have the right to transmit the data to another controller without hindrance from the controller. And technically, the controller must either hand the data over to the data subject in a stable and a usable fashion at their request, transfer that data directly to the recipient of the data subject's choice where technically feasible. So this provision of the right to portability is intended to encourage data controllers to develop interoperable formats that can enable data to be shared. That is data portability. And I gave you an example last week about what is trending now, what we call the open banking, or sometimes you've had banking as a service. Here is a case whereby you can be a customer of one bank, and you find that these people, when their overdraft is very expensive, their loans is very expensive, and you've been banking with this institution for the last 10 years. So we have a lot amount of data that you can use for alternative financial services. So what you do is, if you get another organization or another banking institution which is offering you a very good rates on overdraft, then you can be able to switch over from one bank to the other bank. But now we find that is now very not very possible right now, the situation in which we are, because we've been missing the Data Protection Act, and that is why in Europe they came up with a regulation for the banks to ensure that they can be able to give or allow access to a third party to access the data belonging to a consumer with the consumer's consent. So that is what we call the data portability. You can be able to take your data from one insurance company to another insurance company, all that data with that history, because we are living in a data-centric world. So data is actually the currency, is the new oil. So if you want to move from one controller to the other, they should be able to give you that data in a way that is structured, commonly used, and machine readable format. That is what we call data portability. The right to object. Well, so whenever a controller justifies the data processing on the basis of its legitimate interest, data subject can object to such processing, which means that your data has been collected, and even though it is legitimate, you can be able to object the processing of such data. So as a consequence, the controller has no longer allowed to process the data, subject's personal data, unless it can demonstrate compelling legitimate grounds for the processing. Once you've said no, my data is not being processed, they cannot be able to process it unless they can be able to they can demonstrate that there's a compelling legitimate ground for processing of that data. So this ground must be sufficiently compelling to override the interest, the rights and freedoms of the data subject, such as to establish, exercise, and defend against legal complaints. Just make sure that as a data controller, if you continue with processing this data at the objection of the data subject right, then you need to make sure that these grounds are sufficiently compelling to override the interest and rights and freedom of the data subject. Now, data subjects have the right to object to the processing of personal data for the purpose of direct marketing. So somebody collects your personal data and start hitting you with marketing information. So you can actually object to that. Now, having looked at, sorry. Having looked at data governance tools, let's look at privacy governance tools. We say that, you get so much data to the personal data in the organization, and you'll not be able to handle this manually. And it is estimated that by 2025, there will be around 460 exabytes of data which will be created every day. That is 460 million gigabytes of data handled on a daily basis. So while this flood of data has become indispensable for performing daily tasks in most organizations, the mismanagement or loss of it can result in operational inefficiency, reputational damage, and fines. So the rise of the GDPR or CCPA, that is California Consumer Protection Act, and other data privacy regulation around the globe has put legal obligation on companies to protect this data and manage it securely. So for you to do that, you need what we call data privacy governance tool. So this new regulation have pushed the organization to implement data governance tools to support their privacy programs and manage their compliance. So we find that in the past, most organizations were using things like Excel spreadsheet to map out their privacy processes and manage compliance. And even right now, I know most organizations do not have these tools. They just use Excel spreadsheets to manage their compliance, and this is very inefficient. So privacy governance software tools can automate and streamline the processes of identifying, recording, deleting, and managing new and existing personal information while managing compliance with multiple data privacy regulation. So if you have a tool in place, a software in place, it can help you do this efficiently, while at the same time making sure that you are complying with the multiple data regulation that you might be subjected to. Maybe you are subjected to data protect the GDPR. You are also subjected to CCPA. You are also subjected to the Data Protection Act 2019 of Kenya. Things like so. It's the governance tool, the privacy governance tool, will help you to efficiently manage your own privacy program within the organization. So most of these tools are web-based and can be accessed from any device, providing privacy with the centralized solution to manage privacy compliance across business and third parties. So most of them are web-based. You just and you can be accessed from anywhere. So choosing the right tool that fits your organization unique regulatory landscape is very crucial. You need to choose the right tool that you need within the organization, because there are so many other tools there are so many of these tools in the market. So you need to know which tool is right for your organization. So before selecting and implementing a privacy governance tool, it is important that you understand the personal information flow in and out of your organization. And we looked at this when we were looking at data assessment, because you cannot have a privacy program without an inventory of your data. So, and when you are doing that, you are scoping your privacy program, you need to know what kind of personal information flow in and out of your organization. What are the regulatory requirements that apply to that particular information? How your organization uses that information. So you need to collect all this data and have them at your fingertips in order to know which tool can be best applied to your organization. So gathering information about your current framework and data operation will narrow down your search and drive your software selection decision. So as I told you, these are tools which are there. There are not many, and for you to choose any, you need to have all this information at hand. And this is something that we can as Managecom system really help you to do this within your organization. Which tool is good and how you can be able to implement it. That is one of our functions, our services that we offer. So top privacy governance tools in the market today include OneTrust, Big ID, Naimity, Informatica, Data. All there are quite a plethora of tools out there, but you just need to know which tool is best for you. So which features to consider when you are choosing data? Sorry. Which features are important when you're choosing a privacy governance tool? You need to focus on features that support the privacy and regulatory needs of your organization, and they're flexible enough to scale with the organizational, technological, and regulatory change. So things like, one thing that you need to look at is what we call data mapping or inventory. And we looked at this at data when we are looking at data assessment. Now, this feature provides data mapping and inventory solution that addresses compliance and with record keeping requirements. So this tool can deliver things like questionnaire, process registries, record assets, so organization can visualize the data lifecycle, identify gaps, track recommendation, and remediate potential risks. So that is one feature that you need when you're looking for a data or privacy governance tool. Take into consideration data mapping or data inventory. Will the privacy tool provide this feature? Will they provide data mapping and data inventory? The other thing is what we call data subject access request management. How do you manage the data subject requests? Now, the data subject access request is a common requirement among this most of these privacy regulations such as GDPR and CCPA. Failure to comply with this requirement can lead to financial, legal, and reputational consequences. So DSAR provide you with the ability to access, correct, and delete their data across the entire organization. So once you provide this feature, then your data subject can be able to just log in and delete the data that are not that do not really conform to what they've given you. There's also a feature on vendor risk management. Remember, we looked at third-party risk management when we were looking at privacy, our privacy program. So when you are choosing a tool, make sure that it has this feature, vendor risk management, because this feature evaluates and manages the data risks to protect against potential breaches and non-compliance. It assesses, monitors, and mitigates risk between company and its third party. So you make sure that whatever tool that you are going to put in place is taking care of vendor risk management. The other thing that the other aspect that you need to look at is consent compliance, which integrates with the existing technologies and workflows within the organization to maintain a consent audit trail in order to demonstrate compliance with the global privacy regulation. Remember, consent is something which is very important because you cannot process data, personal data, without the consent of the data subject. So consent compliance is a feature that the tool that you are going to put in place must be able to have. The other thing is cookie consent management, which is a feature that can automatically detect cookies and other tracking technologies related to your website and tailor your banners and preference option for visitors. The other feature you should also look at is what we call behavioral advertising compliance, which is a feature that helps organizations manage cookie compliance when it comes to online advertising, which is a challenge to many organizations. So this feature notifies the individual on when and how their information is being used for online advertising and their rights to regarding the use of that particular data. The other feature we need to look at is what we call assessment automation, which is a software that creates and analyzes privacy impact assessment. Remember, we talked about the privacy impact assessment and the data protection assessments, and it will guide you on the use of personal information across the organization. So you must make sure that the privacy tool that you're going to implement within your organization has this feature. The other one is the privacy awareness, which is some privacy governance solutions provide tools that help employees expand their privacy awareness through training, educational resources, and test exercises. Remember, and awareness is very important within the organization for your data privacy program to take shape and make sure that it delivers what it's expected to deliver. The other feature to consider is data transfer risk mapping, which has in which certain solutions help organizations understand the risk associated with transferring data outside the organization and across the globe and how to address this risk while maintaining compliance. Remember, international data transfer. How are you going to manage it? So you must make sure that the product that you are going to implement to address your privacy governance must be able to take into consideration the data transfer risk mapping. So what are some of the benefits of privacy tools? We say that instead of using Excel, you can approach us as a company, and we can be able to help you choose a tool that is going to help you with your data or your privacy program management within your organization. So we can be able to help you with that. Now, what are some of the benefits of a privacy governance tools? First of all, there is empowered decision making. Privacy governance tools offer enhanced reporting features like data visualization, making it easier for you to communicate privacy risks and the effectiveness of your privacy program to your board, which is very important because you'll always be reporting to the board, because privacy is something that has gone to the board level. So you need a tool that is going to help you with decision making and helping you to making sure that your board also understand what you're doing. So improved reporting allows your executive leadership to make informed decision on the business. So you need to automate this so that you can be able to make proper decisions. The other thing is, the other benefit is improved compliance, which means that it provides a platform for ensuring regulatory requirements are met, compliance monitoring, and even automating compliance completely. So these features include things like streamlined ways to manage compliance across a host of regulations and to seamlessly evolve your privacy program with regulatory change. Because you remember, you can be an organization and you are subjected to various regulatory compliance, and you need to make sure that you meet all of them. So it is important that you have a privacy governance tool to help you do this. The other thing is the data mapping, which is, it is impossible always to protect personal information if you can't effectively monitor where that data is or who has access to it. So data mapping is something which is very important, and privacy governance tool will help you do exactly that. So privacy governance tools can provide faster data harvesting across systems and have ability to find information about data objects, their physical location and characteristics and usage. The other benefit is operational efficiency, which is streamlining privacy compliance across regulations, systems, geographies, departments, and third parties, which is something that can be insurmountable task when you are doing that manually. So it is important to employ the privacy governance tool. So privacy solution provides centralized management of processes, policies, procedures, third-party vendors, and asset across business applications and borders and business units, significantly improving the operational efficiency. So employing a privacy governance tool will help you automate all this. The last benefit that we put here is increased return on investment, or the ROI, by preventing costly fines for non-compliance, reducing the risk of reputational damages, and improving operational efficiency. Your organization can spend less resources managing risk and reallocate these new funds into other areas of your privacy program or business. So it will give you a clear return on investment, because you are going to prevent costly fines, things like reduction to the risk of reputational damage or brand reputation, and improving your operational efficiency. So these are some of the reasons why you should be able to get a privacy governance tool within your organization to streamline and to manage your privacy governance or your privacy program management. Now, that brings me to the end of today's presentation, and I hand it over to Achilles to continue from there. Thank you.
Thank you, Mr. Tinga, for the good presentation that you have made. And I think we have a few questions that members have raised. Who still have concerns, they have questions, it's your time. You can raise up your hand. You can ask your question in the Q&A section, and whatever you think is best for you to ask the question. I think we have heard the presentation that our expert has made. And now if you have any question, please, it's your time to ask it here. Any question, we are good to go to take all those questions and have Mr. Dinga answer them. On the Q&A section, we have one question from Mahmoud Amino. Sorry if I'm pronouncing your name incorrectly. He asks, if I will be processing personal data obtained from a third party, what obligations should I have to check that it has been obtained in an appropriate manner?
Now, when you are processing this data, are you processing you need to consider, are you processing this as a data processor or as a controller? You have to look at that, because when you are processing as a processor, then the obligations, all the obligations fall to on the data controller. They're the ones to make sure that data which was obtained from a third party is the right data and is accurate and it represents what it's supposed to represent. So you have to look at it from the 2 points. One, from the data controller, in which case the responsibility is on you to make sure that the data that you are receiving from the third party is the right data, is accurate data, is data that speaks of what it's supposed to speak before you start processing it. That is your obligation. If you are a processor, or in fact, a processor cannot receive data from third party, maybe with the consent of the controller. So remember, the controller is the one giving the obligation to the data processor to process that data. But in case they process data from a third party, they must have got the concept of the consent of the controller to get it from the third party, and then the controller is supposed to be the one responsible to make sure that the data that they are processing are accurate. Yes.
Thank you, Mr. Dinga. Hopefully it answers the question by Mohammed. If you have any follow-up question, you can just type it in the Q&A section, or you can raise up your hand for a follow-up question. Again, Mr. Mohammed also asks another question. How does data protection legislations interact with freedom of information? How does data protection legislations interact with freedom of information?
I think you'll find that in many jurisdictions, this freedom of information could be enshrined on the national constitution. Okay, and the data protection act or legislation that is coming into place is not always going against the constitution, but it will just be able to strengthen some clauses of the constitution. So you'll find that where there's the freedom of information enshrined in the constitution of a given country or a given jurisdiction, the data protection legislation will only strengthen those particular clauses that are dealing with the freedom of information. And what is important with the data control or data protection legislation is that they make sure that the data that you are collecting, which are the personal data collecting, processing, and storing, it meets the requirements, which could be either enshrined in the freedom of information clause of the Constitution or otherwise. But they are just there to strengthen or whatever freedom of information or the pieces of legislation where it is enshrined within the national constitution.
Thank you, Mr. Dinga, for that clarification. There is one person here called Esomba Ambassa. She asks, how can a person whose data are used in a bad way claim for his or her rights?
When a country has got data protection legislation, there will always be clauses within that particular legislation on how you can be able to claim if your data has been used in a bad way. Because you remember what we looked at on the rights of a data subject. Some of those clauses that we've looked at, so some of those rights, they are clearly enshrined in a data protection legislation, like the one which we looked at. I got them from the GDPR. So if you are subject to GDPR, there will be always those clauses which shows how exactly you can be able to claim if your data has been used in a bad way. They will be always be provided within the national or legislation on Data Protection Act.
Thank you for answering that question. Colleagues, if you still have more questions, please post it on the Q&A section, or you can just raise up your hand so that Mr. Dinga can respond to your questions or concern. Now, there's another question from Elsin. He asks, can we consider as personal data the cookies that websites oblige us to accept before accessing their website?
Can we consider?
Can I repeat? Can we consider as personal data the cookies that websites oblige us to accept before accessing their website?
Normally, cookies are not actually personal data, but they are instruction within they are personal data because they are instruction within the website which tells you what kind of information they are going to collect when you are browsing their website, and what is the possibility of using those information for other purposes if you consent to it. So it depends on what kind of cookie that you are actually obliging to accept before you access their website. So it is personal data, but you see, it is personal data that is collected with your consent, because that is why it is important to read those cookies before you are obliged to access. So if that some website will always tell you accept all cookies, or sometimes tells you reject all cookies, in which case maybe there are consequences of rejecting. Maybe there are certain type of information that you not access from the website, or they're telling you accept all cookies. But now if you accept all cookies without you knowing which kind of cookie you are accepting, now you are also putting yourself into an awkward position, because they can now use your data, and they can be able, you cannot claim, because they'll be able to say that before you accepted to access this information, we asked you and you consented to us harvesting your personal information. So yes, those are personal information which are collected according to you having given them the consent to do that.
Thank you for the clarification. We have someone called Bungaya Panga, makes a comment that, thank you, Mr. Dinga. It's a new knowledge to me, but very applicable in our daily business transactions. Thank you again. Well, I don't see any other question. Yeah.
If you need my help in terms of helping you to craft privacy management program within your organization, I can be able to help you with that, and at the same time, we'll be able to help with the right types of tools that you can use to automate this, because this is, if you can see, is a plethora of information that you cannot do manually. You cannot be able to use an Excel worksheet to do your inventory, to do your data mapping. These are things that you need to automate. For example, if you are doing something like a privacy impact assessment or data protection impact assessment, there are questionnaires that you need to develop and send them to the people who need to answer them. Now, how do you develop this question? You don't need to reinvent the wheel. You can just have a privacy management tool, and these questionnaires can always be generated automatically using the tool. So I strongly encourage you people who are dealing with privacy to consider implementing privacy management tool or privacy governance tool.
Well, thank you. Trying to locate other questions here. Miss Christine asked, what is cost involved? I not get these questions clearly. Perhaps you can type it afresh. We have one hand raised. Our IT can allow this person to speak. We have one hand from Elmat. You can allow our member to speak. Is David Ngerish. Okay, let me allow. Yes, David, we have seen your hand. Can you ask your question? Unmute and ask your question. David, sorry, I'm pronouncing your name improperly, but we see your hand raised. Please, can you go ahead and ask your question?
He is muted.
Okay. Please, if you're trying to speak, kindly unmute. David, kindly unmute. Okay, Christian asks, what cost is involved in come up with the data privacy tool? The speaker says he can help in that. Your comment, sir.
The cost involved
in helping an organization to come up with a data privacy tool.
I think if you have my number, you have my email address on the presentation. Now, if you want particular help in terms of helping your organization to come up with the privacy, then I think you just inbox me, and then we can have one-to-one conversation regarding this, rather than having it an open air conversation.
Well, I think we are going to share your contacts so Christine can be able to contact you on so Christine or Mr. Dinga will be there to have a discussion with you. Again, we have another question from Mohammedu. He asks, what are the exceptions from a subject access request? What are the exceptions from a subject access request? I don't get the question clearly unless Mr. Dinga can construe something.
I'm not very sure what the means by that. Maybe because we talked about the the right of access, which is the right to obtain from the controller confirmation as to whether or not personal data concerns which concern the data subject, how the purpose of the processing, the categories of personal data being processed, the recipients of that data, where possible, the period in which that data is supposed to be stored, and the criteria used to determine those periods. So I don't know what exactly it means by exceptions, because these are very clear on that presentation that you are going to share with you.
That is clear. I not see any other question. Some people are asking about the presentations, the slides. We shall share the same, so don't worry. And all the recordings can be accessed through our East Africa Law Society YouTube channel. So you just have to subscribe and get to learn what is contained therein. I not see any other question. And I think we can close this session. Now I will welcome Mr. Dinga to give his remarks before we officially close. Mr. Dinga, you have the floor.
Just take this opportunity to thank everybody for having to spare your time to attend this webinar. This privacy is something that is a new area, and you'll find that many organizations, many jurisdictions or countries have not come up with the privacy laws or legislations. But given that many organizations may be able to employ even people who are coming from the EU, then they find that they are subject to GDPR. So it is important to know these pieces of legislation concerning data protection, and what I can assure you is that you can use our services when you need to implement privacy program within your organization. Is a journey which cannot be completed at once. So what you need to will work with you slowly by slowly to ensure that you meet the compliance requirements. At the same time, you make sure that you are shielded from unexpected data breach. So we'll help you in terms of consultancy, and which as well will also help you in terms of implementing technology to take care of your privacy within the organization. So contact me if you need any help. My contact details are shared by ELS, and I hope that I look forward to getting inquiries from you so that we can move together in this journey, which is a new territory. Thank you so much.
Thank you, Mr. Dinga, for that remarks. Dear members, As we promised, we shall be awarding certificates to all members who have attended successfully all the 3 webinars. So information certificates will be shared. On another note, we thank you, Mr. Lawrence Dinga, for an enlightening and entertaining presentation on privacy in an enterprise. We appreciate having this mysterious area clarified, and indeed, we have learned a lot from this webinar. Hopefully, the skills and knowledge that participants have acquired in these webinars will be useful to the organization they work with and for their professional career. On behalf of ELS Governing Council and on behalf of the ELS Secretariat and on behalf of all members, we thank you very much for always being available to train our members. Every time we ask for your guidance and clarification, you have always been there for us. We don't take it for granted, and we indeed thank you very much. To our members attending this webinar, this marks the end of this webinar series on privacy in an enterprise, and we have other sessions on IT which will be communicated to you shortly. So we shall keep you updated on the same. Meanwhile, you can follow us on Twitter, Facebook, Instagram. Also visit regularly our website to get updated on all the activities that the Secretariat is doing. All the presentations, recordings have been uploaded in our YouTube channel. Kindly subscribe to it. It is called East Africa Law Society YouTube channel, so that you can enjoy listening to all the sessions that perhaps you might have missed in the past. The presentation and recording for this webinar will be shared to you via emails. I wish you good evening and hope to see you in our next trainings. Thank you, and we wish you luck in your professional career. See you next time. Bye.
Thank you. Bye-bye.